God save the state and this honorable court.
Good morning. Before we begin the argument, I want to welcome from Apex Friendship Middle School the students and faculty, staff, parents, others that worked to ensure that they could be here this morning. Let me commend you for being here with us. Now, let me go ahead and answer a couple of questions that you probably have on your mind, which is where do the people take the witness stand to testify? We don't have witnesses in this court. And where do the jurors sit? Well, we don't have jurors in this court. Well, you may be thinking, well, then what do y'all do? We decide issues, matters of law. And you're going to hear the attorneys argue the issues in this case. Perhaps when we're finished, the attorneys may have time to talk to you briefly about kind of this process and what goes on, and I and other members of the court may be able to stick our heads in and at least say hello. What we can't do is talk about the case. So again, I welcome you and I applaud you for your interest in civics in our judicial branch. That being said, I will go ahead and call our next case, which is Ha versus Nationwide Insurance, and we'll hear from the appellant.
Good morning, Your Honor. If it please the court, Chief Justice Newby and the Associate Justices of the North Carolina Supreme Court, my name is John Kirby, and I represent the plaintiff appellants in this appeal. I would like to reserve 5 minutes for rebuttal. I am pleased to have my clients with me here today. They're seated in the front row to your left. This is the second time that the case has reached this court. The first time we were here, it was a WebEx hearing, so I'm glad to be here in person. This is the second time the case has made it up here. This case presents a single issue for review, which is what type of notice is a homeowner entitled to when his insurance company that insures his home cancels his policy. Our position is that pursuant to the statute and other authorities, that he's entitled to actual notice that his policy has been canceled. The position taken by Nationwide, the insurance company in this case, is that the policy can be canceled by the mere mailing of the notice, even if that notice is never received. We suggest to your honors that the answer to this question is that the policy can only be canceled if the insured receives actual notice that his policy has been canceled, and we will suggest to you and argue that this results from several different sources. One of them is prior decisions from this court. Another is the overwhelming authority of cases from other jurisdictions addressing the precise same issue. And finally, looking at the public policy considerations that also impels this same result. The basic facts of this case are fairly straightforward.
I think we're pretty familiar with the facts at this point. I had some questions, so I want to start by seeing if I can narrow what you just said and understand the source of the argument.
Yes, sir. So
suppose there was no statute dealing with this matter and there was no standard policy form from the Commissioner of Insurance. So all there is just an insurance contract between the insurance company and the policyholder. If that contract first had the statutory language, so the policy can be canceled by giving notice within 5 days to the insured, and then after that had the language from the standard policy form, so it said cancellation can be done by mail and proof of mailing is sufficient. Do you think there's any ambiguity just in that contract?
I would say no, Your Honor. And just to put your question in a little bit further context, whenever we deal with cases of insurance, insurance is fundamentally an area of contract law, but it's a specialized area of contract law that has special regulations, special statutes, and the courts have enunciated certain principles of interpretation that apply to policy. But fundamentally, a policy of insurance is a contract, and pursuant to freedom of contract, which still exists, unless there is a statute on point, and unless it's unconscionable, the parties can agree to any type of coverage or provisions that they want. And
right.
Yes.
So really the question we're looking at here in this case is that, because that is in fact what this contract says, because the statute is incorporated by law into the contract, and then they used, as the law required, the language from the standard policy form. So am I correct then that your argument is that is what the contract says, but by law it cannot say that because the statute in your view, does not permit the type of notice provision that's in the standard policy form, and you think the statute cannot be overridden and that controls the case. Is that your
Yes,
argument?
sir. I would say that with perhaps one slight modification. So we have the statutory provision, which is 44, chapter 58, 44-16, which applies to fire policies. And that has certain language in it about what must be done to cancel the policy. The policy itself, and that language, of course, we are arguing requires actual notice. The policy language, on the other hand, does have the provision stating that the policy may be canceled by the mere by the mere mailing of the notice of cancellation. So what we have here is a statute which provides one level of protection or terms and a policy which provides another. The fundamental principle of interpreting these that has come out from many, many decisions from this court as well as the Court of Appeals is that basically in that situation, the insured gets the better of whichever of those is more favorable to the insured. If the statute is more favorable, the insured gets that. If the insurance company wants to write a policy that provides additional protection, they're free to do so. So the insured basically gets the better of whichever coverage or provision results from either the statute or the policy. So yes, what we are saying here is that the statute requires actual notice, and the policy provision cannot trump the statute. And there are many, many cases in North Carolina, both from this court and the Court of Appeals, which have held that a given policy provision violates a statutory provision, and in that situation, the statutory provision prevails. A lot of those cases arise in the context of automobile policies, but it's the same principle. We have cases involving liability insurance, uninsured motorist coverage, and as well cases involving homeowners coverage. But yes, essentially, the statute cannot be overridden by the policy, but the insured will get the better of whichever of those provides him or her with greater coverage.
So really then, this case presents a question of statutory construction, because what we need to figure out then is what the statute requires in order to know, is there some conflict between that and what's in the standard policy form, which is, if there was any kind of ambiguity, it's resolving it. And the reason I say that is, does that really mean that we're using tools of statutory construction to figure out what does it mean to give notice? We're just trying to interpret what that means in using the tools of statutory construction. Would you agree that's what we're trying to do?
That is correct, Your Honor. And much like the previous case that was before you, and some 30 years ago, when I was a younger man, I walked these halls as a law clerk, and I clerked in this court, and I saw many cases where the court, of course it was different judges, but back then, had to deal with issues of statutory interpretation. It's the exact same principles that have been around the last 30 years, the last 100 years. Yes, we look to legislative intent, and the most controlling thing we look at is the language of the statute. Is it plain? What can we divine from the plain language? Sometimes we bring in other principles. Is there some ambiguity? Is there some principle of construction? So, for example, in the insurance world, there is a principle of construction that if there is ambiguity, that is construed in favor of coverage. But yes, Justice Dietz, the fundamental question here is interpreting North Carolina General Statute 58-44-16, and what does it mean when they wrote what's required for a fire insurance policy, which includes a homeowner's insurance policy, to be canceled. So the language of that statute says that it may be canceled by the insurance company giving written notice to the insured, 5 days written notice prior to the cancellation. That's
so let's
the
just
operative
simplify
language.
to say giving written notice. The statute requires the insurance company to give written notice to the policyholder.
Yes, sir, that is correct.
And you would agree that give or giving is not a defined term in the statute, so we just have to use its ordinary English meaning, what the word give means. Do you agree with that?
I would fundamentally agree with that. I would go a bit further, though, and I would say, again, there are decisions from this court from 90 years ago addressing the exact same verbiage, the exact same statute. It has been recodified, but it's not as if we're writing on a blank slate. We have cases from this court addressing the same language. We have cases from around the country addressing the exact same issues. So yes, we are fundamentally trying to determine what did the legislature mean when they said give notice.
One thing that is difficult about that word, give, is that if you look at just ordinary English usage, if you look in dictionaries, it really functions in two different ways depending on whether the giving is something that sort of occurs instantaneously or whether there's some separation in space and time, so some intermediary that is involved in the process. So for example, if I was at someone's birthday party and I had a gift and they said, why don't you give, the birthday girl her gift? And I walk up with the gift, and just as I'm handing it over, someone else comes up and taps her on the shoulder and says, happy birthday, and she doesn't take it. If I walk back to the crowd and they said, did you give her the gift? I mean, no English speaker would say yes. They would say you attempted to give the gift, but it didn't happen. Because giving the gift happens when I hand the gift to someone and they receive it. But there are other ways to use the word give. So for example, if I was setting up a Zoom call like the one we did in the last argument, and I was to say to one of my law clerks, give everyone the Zoom link. And so they sent an email to everyone with the Zoom link. But somebody didn't get it because it went into their spam folder. I couldn't walk into my law clerk's office and yell at her and say, why didn't you give everyone the Zoom link? She did. Just one of the people didn't receive it. And I think the difference conceptually is because sometimes the giving and the receiving are separated in space and time, either because someone else is taking over the delivery process or because there's electronic means or that sort of thing. Doesn't that create, because the term's not defined, an ambiguity that we'll need to resolve somehow?
So I have two responses to that. My first response would be, if there is an ambiguity, if the court determines it is ambiguous what that means, I submit that that means the plaintiffs win this case, because when there's ambiguity, all the case law indicates if there's ambiguity in the statute involving the homeowner's insurance, or it can be auto insurance, that ambiguity or that tie goes to the runner.
I thought, hold on, I thought that, and this is what I'm struggling with, I think that case law precedent is saying we interpret the language of the policy if it's ambiguous in favor of the policyholder. And the challenge for you if we're using that case law is that the insurance company, the ambiguity is resolved, and not by the company, but by the government, the Commissioner of Insurance, who said, use this language, which resolves the ambiguity. So, isn't that a problem for saying we have to construe it in favor of the policyholder? Because there is no ambiguity in the actual contract. So how do we get from there's true ambiguity in the statute, but not in the policy, to saying there's some conflict between the two?
So yes. So just to be clear, the rule of construction, which says that we construe the ambiguities in favor of the insured, that actually applies both to the policy, and it does apply if there is an ambiguity in the statute. It applies in both situations.
But isn't that just to the provisions in the statute that are the ones incorporated by law into the policy? Do we construe just it's just a provision in our general statutes that deals with insurance coverage, and we would say we construe every single one of those statutes in favor of the policy? I thought it was just the ones that are putting something in the policy, language in the policy.
Well, actually, you're right. Actually, any statute, yes, any statutory provision that indicates the rights or benefits that an insured has. Right. So those are essentially the ones that are written into the policy. If there's ambiguity in those, then those are to be construed in favor of coverage and in favor of the insured, but both as a matter of contract law and as a matter of statutory interpretation. So yes, so the first question is, what does this language mean when it says give or giving notice? And our argument is that if the notice is not received by the homeowner, it is not received. And again, there are several reasons that we reach that result. And Your Honor, Justice Dietz has raised the other question, which is one of Nationwide's arguments. They make an argument that the Commissioner of Insurance has weighed in on this. So that's another point I was going to address at some point. But just to jump to that point now, since you have raised that question, one of their arguments, and it's first interesting to note, they don't approach this from a plain meaning standpoint. That's our approach, plain meaning. They have other arguments kind of go around the plain meaning approach. One of their arguments is that the Commissioner of Insurance, because he, according to them, approved this policy language, that somehow means that's what the statute means, or that's what the Commissioner understood the statute meant. I think that's the argument that Your Honor, Justice Dietz was alluding to. But as we've outlined in our brief, there are several reasons that argument doesn't work. One of the arguments is that the Commissioner of Insurance, there's no indication that he has ever actually specifically looked at or interpreted or enforced these approximately 2 lines in a 63-page insurance policy. The doctrine they're relying on is something called judicial acquiescence, The idea behind that is if a state agency has actually been enforcing, interpreting, actually applying a statute, and it's been in existence for many years, and the legislature has not changed it, that the courts can infer the legislature is happy with that. That doesn't apply here for two reasons. The first reason is that the Commissioner of Insurance has never actually applied or enforced or interpreted this provision of the statute. At best, what he did is he received a 63-page insurance policy and did not reject that policy. The case on judicial acquiescence, they cite three cases, but one of them, for example, is the case of Wells. That was actually a case involving former Court of Appeals Judge Jack Wells, where he had a dispute over his retirement benefits, and this court adopted that argument. But in that case, you had the state treasurer had actually been enforcing and applying the retirement rules for retired judges. It wasn't just that the state treasurer had somehow kind of blanketly approved some document, but he was actually applying the rules pertaining to how retired judges receive their benefits. And this court said in that context, that is to be given some weight, the fact that the legislature has not changed to that result. In this case, there's no indication the Commissioner of Insurance has written any sort of letter, any opinion, any decision indicating that this policy language essentially trumps or redefines what's in the statute. The other fundamental problem is, and this gets back to what I was saying before about the issue of the insured getting the greater coverage, their argument seems to be that the policy provides for, in essence, a lesser means of notice. The policy says it can be canceled by the mere mailing of notice. The statute says you must give notice. Their argument is essentially to take the statute and then drop it down to the level of the policy, giving the insured the lesser of those two coverages.
Let me reframe their argument a little bit, because I agree with you. I'm not particularly persuaded by either legislative acquiescence or judicial acquiescence, because I think it's easy to find a lot of flaws in trying to assume that inaction means anything. But I also understood part of their argument to be that from the position of this private company, the insurer, they have no choice but to use the form that the Commissioner of Insurance instructs. It would be illegal for them not to include that language resolving the ambiguity in their policy. And so what they're saying is the statute itself does not give a clear answer. It's ambiguous. And then the government told me, use this language that resolves the ambiguity. So I entered into a contract with my policyholder that as the company that has no ambiguity, how can I now be blamed for that fact? So what's your response to that?
So just a couple of points on that. So the insurance policy we're talking about here, this is not something that the Commissioner of Insurance or the North Carolina legislature passed or adopted or enacted. These are standard forms. This is called the HO3 policy. It's enacted by other bodies, or it's drafted by other bodies, and then it's submitted and reviewed. So it in no way necessarily expresses or reflects the policy of North Carolina. That again would be reflected through the statutes. The larger
But am I right that
yes.
if the Commissioner of Insurance doesn't approve it, that it's not a valid standard fire policy?
That would be correct.
So there is some requirement that the government said this is what you must use to the private sector. I mean,
yes, sir. The simplest answer to that question is this. Even if all of that is true, here's all that would mean. The end result would be you have a policy that has a written policy that has certain terms. You have a statute that has other terms. Getting back to what I was mentioning before, the insured still gets the better of the both of those. His coverage and protection isn't lower to the other. There's no sort of problem. There's no sort of conflict here. It's not as if what is in the statute is reduced to what is in the policy. The two can exist together. And incidentally, there may be some situations where the policy may provide the insured with extra time. The policy, for example, it provides for a 10-day notice period running from the date of mailing. There may be some instances where that provides the insured with greater coverage. There may be other instances where the statute does. And our position is quite simply these two can exist quite harmoniously. And as has occurred in many cases, the insured simply gets the benefit of whichever provides him or her with the greater coverage.
let me ask you what seems to me to be I think the strongest of the arguments we're going to hear for your friend, for the insurer, which is that if the statute said, for example, you may not serve notice of cancellation or give notice of cancellation by mail, and then the standard form said you can give notice by mail, our case law would say that provision is inoperative, that you can't override the statutory provision either through approving the standard form or just by inserting language in your policy as the insurer. But they're saying that's not what's going on here. What's going on is the statute is ambiguous. It's not clear what is permitted by giving. Does it mean receipt is required or not? It is just sort of hopelessly ambiguous. And in that scenario, when the government is then telling the insurance industry, you must include this language, and when they put that language into their policy, there's no ambiguity anymore. It's resolved that they can't be held accountable. The contract that they used with their policyholders has no ambiguity, and your beef is really with the Commissioner of Insurance approving what, in your view, is inconsistent with the statute, not with this insurance carrier. So what's your response to that?
So again, just to be clear, our position is that the statute actually is not ambiguous. The statute, when it says give notice, means actual receipt, again, supported by precedent from this court 90 years ago addressing the same language. 10 to 15 opinions from across the country addressing the same language.
Suppose we don't agree with you. Give me your best argument if we don't agree with you about that, if we think this is ambiguous.
Even if it's ambiguous, we're still back to the point I made before. Let us even assume that the statute is ambiguous and that the policy provides the 10-day provision by written notice. Our position is that that language in the policy doesn't somehow clarify the ambiguity in the statute. If we were to assume there's ambiguity in the statute, we still have to apply principles of legislative interpretation as to what that means. And of course, there are other differences. One of them, of course, has a 10-day provision. 5. They're fundamentally, there are differences in the two. But the statute still stands alone, even if hypothetically it were ambiguous. The policy doesn't clarify the ambiguity. It simply provides the insured with another source, another resource for coverage and provisions. But the two can exist harmoniously.
What's the, I'm sorry.
No, go ahead. I'll wait.
Sure?
Yeah.
What's the point of the 5-day notice requirement?
Well, quite fundamentally and quite simply, it is very obviously, it is to give the insured whose homeowner's policy has been canceled, and again, for many people, their home is their most valuable asset. It is to make sure they have notice that this has been canceled so they can go out and get other coverage.
So it's to give them at least 5 days in which to obtain other coverage.
Well, yes, sir, that is correct. It is the very clear purpose of this. Cases from this court have said this provision is designed to protect the insured, and that is the clear reason, and that is the advantage to our interpretation, is that the insured is at least entitled to 5 days notice and has time to go out and look for other coverage.
And if that notice is not received, does the insured get the 5 days intended by the legislature?
Yes, I would say two things. For one, if they don't receive that, yes, they would receive the 5-day provision. But in addition, if they don't receive the notice, then pursuant to the case law, which indicates that the cancellation requirements have to be substantially complied with by the insurance company, or I should say strictly complied with, if the insured never receives the cancellation notice, then the policy, in fact, remains in effect, not just during the 5 days, but beyond the 5 days. And
I guess what I'm asking is, if we adopt the rule that mailing is sufficient, receipt is not required, are we frustrating the legislature's intent, that is the intent to provide the insured with a 5-day period in which to obtain other coverage?
yes, sir, if I could address that. Yes, the short answer to that would be absolutely yes. And I see I'm getting a little bit lower on my time because we've been addressing a lot of very important issues. But just to address that just very briefly, there's a lot of issues and sub-issues that get raised in this case. One of them is how reliable is the mail, how fast is the mail. But if we start from the assumption and the presumption that looking at the statute, the intention was to give the insured 5 days notice so they can go out and get other coverage to protect them. If we start from that premise, if we actually look at statistics on mailing, and these statistics have been cited, they cite some studies on in a footnote on page 32 of their brief that talks about the average times. The post office basically keeps this data, so we have data. So basically, 98% of the mail is in fact received within what they call the service standard plus 3 days. Service standard basically means their target. So if you translate all this, what it basically means is that if you're mailing something in a local area, from let's say Raleigh to Raleigh or Raleigh to Cary, 98% of that mail will get there within 5 days. That means if we flip it around, 2%, 2 out of every 100 or 20 out of every 1,000 is not going to get there within 5 days. So those people, let's say the 2 out of 100, they're going to get that mail on day 6 or 7 or 8 after it's sent. This is pure statistics from the U.S. Post Office as to how long things take to arrive. There will be some homeowners that get that on day 6, 7, 8. They absolutely, under their interpretation, which is that the homeowner only gets 10 days from the date of mailing, they will be cut down to just 1, 2, or 3 days to receive notice. And of course, then we have all the people out there whose mail gets delayed, the mail gets delivered across town. For any number of reasons, the mail just plumb doesn't get there. Those people get 0 days notice, which is what happened to these people. They got no notice. They didn't get 5 days or 4 actual notice. They got 0 days of actual notice.
But I also have a question about the facts here. Even assuming that the statute, when it says gives notice, means actual notice, and I understand that the trial court found as fact that the notice of cancellation was not received, but didn't they also find as fact that the premium check was returned and that was received? And why didn't that give your clients actual notice that the policy had been canceled?
Yes, and this is addressed in the order of Judge Holt, who wrote this order. Yes, they did. So Nationwide, after they canceled the policy, they issued a refund of that premium. The way the refund comes, though, it's just a standalone check. There's no explanation. There's no documentation as to what that is. They also had their vehicles insured with Nationwide, so when they got this check, they didn't know what it was. And Judge Holt expressly addressed this in her order. She expressly found that when they received the notice, A, they had their autos insured with Nationwide, but B, they did not know what this check was for. So yes, they did.
It had the policy number on it, right? That was a finding of fact.
I'm sorry, I don't recall that finding, but that could be correct. But of course, that's a tiny number. Yes, I mean, it may have had the policy number on there. Most people don't know their policy number, but at best, that could have alerted them that something was going on with the policy.
And they just had a policy canceled for the unfenced pool and the trampoline.
Well, that's the same policy we're talking about here. This is the same Nationwide policy.
No, the AAA policy was previously canceled for these same reasons that Nationwide canceled.
Yes, they had reached out to AAA, and I can't recall if a policy was ever written or not. My recollection is that policy was never written. I could be mistaken on that, but yes, they had reached out to AAA, and they did not go with the AAA coverage. So I see I'm under 5 minutes, so unless there are any.
I do have one more quick question.
Yes,
I'm sorry, eating your time, but getting to the policy argument, there is we can speculate about why the 5 days is in there, which is to make sure that there's time for you to actually receive the notice and then take some action to, for example, get another policy. But that's just speculation, and we could speculate the intent is sort of the opposite as well, though, right? Which is that the lawmakers said giving, meaning just go ahead and put it in the mail within a time frame that will give you the 5 days, knowing that many people, probably most people, don't want their insurance policies to be canceled because if you're still paying your premiums, presumably you want your policy. And so this was done to make sure for the insurers that they don't have a problem with people evading the receipt of the cancellation in order to keep the policy in place. And so that's why they chose the word give, which has the interpretation here I think your friends from the insurer are going to argue. So isn't the problem that we really can't speculate? We have to use just the language because we can't speculate about what the intent would be here. There could be multiple reasons.
Well, the intent is clearly to benefit the insured. And again, if we look at the body of case law that has addressed this provision, it is to benefit the insured, and it is to give them time to go out and get another policy. There are statutes where the legislature has specifically written that the mailing of something is sufficient. In other contexts, and we cite these statutes in our brief, in other contexts they have specifically said that the mere mailing is sufficient. So where the legislature intends that, they can very clearly write that. And they didn't do so here. They used this other language of the giving of notice. And the ultimate question that's presented here, once we boil it down and get past issues of statutory construction and all these other things, the real fundamental core issue here is who bears the burden of proof, who bears the burden of loss if the cancellation notice is not received. Our position is quite simply that Nationwide can decide whatever method it wants to cancel its policy. It has to be written, has to be the 5 days notice. It can be mail, certified mail, FedEx, they can deliver it. It can even be email. They can choose whatever provision they want, but that decision is in their hands. If there is a problem, and for whatever reason that is not delivered, the question becomes, does that risk fall on these people who got a policy of insurance, put it on auto pay, paid the premium, had no notice that it was canceled, and are sitting at church on a Friday night and find their house is burned. Does that burden fall on them if that notice isn't received, or does it fall on Nationwide? We simply submit it falls on Nationwide. They're in the better position to assume this risk, to decide what means of delivery is best. They can decide if it's mail, certified mail, and if it doesn't get to the insured, then that simply falls on them. So I would like to reserve a little bit of time, but I'm getting very low. Yes. Thank you.
Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court, Mr. Chief Justice and Associate Justices. I'm Stephen Feldman of Robinson Bradshaw. I represent Nationwide. Appointed at the start of the argument, we've ceded 5 minutes of our time, thanks to the court's permission, to Mr. Brock, who will speak for the Rate Bureau as amicus. I'm not sure the best place to jump in. There are lots of places to start, but maybe I'll start with the questions from Justice Dietz and his colloquy with my friend Mr. Kirby about, sort of what's the framing of what's going on here. And I think Mr. Kirby said something to the effect of, Nationwide doesn't argue the plain language or the text as a starting point. That is not right. If you look at our brief at pages 12 to 14, that is our first argument. Our lead argument is, let's start with the text and figure out what that text says. That's what this court's teachings on statutory interpretation say. And where we come out is, I think, along the lines of the questions from Justice Dietz, which is, let's look at the words, let's look at the context. We're talking about a written piece of paper. How do you give a written piece of paper to an insured? You put it in the mail. And that is what the Court of Appeals rightly decided. That's what the trial court rightly decided. And then the second question is, does the statute say anything about how notice is proven? And that's a separate inquiry from what method or means of notice is allowed. And I don't think Mr. Kirby or the plaintiffs have challenged the fact that proof of mailing provisions, being sufficient proof of notice, are uniformly approved by courts across the country for all kinds of good reasons. One of them is evasion of service. Another is, as Mr. Kirby points out, he beat me to the statistics. Mail's not perfect, but it's very, very reliable based on the statistics of the Postal Service. So overall, you could start and end with the text.
But aren't there also a lot of cases that say proof of mailing, or in a lot of contexts, proof of mailing may create a presumption, but that can then be overcome if the notice is not actually received?
Thank you, Justice Earls. This is an important issue. The question that Justice Earls asks sort of hints into or leans into this area of law called the mailbox rule, which says, as a common law presumption, if you put something in the mail, it's presumed to be received. And so you might think, well, isn't that a reasonable protection here? The answer to that is no. And the reason why is, under reported appellate decisions in North Carolina, merely by saying, as someone who is supposed to receive the notice or did receive it, say, I didn't get it, that creates an issue of fact that's triable. And there's an interesting case from the business court, obviously not binding on this court, but recent, called Morgan, in which the business court says, look, it's very hard to prove non-receipt. It's like proving a negative. So as long as you say, I didn't get it, you've created a triable issue of fact. So that does not really give the insurer or someone who's mailing something any meaningful protection. And that pivots to Justice Earl's question of, well, what's the point of this proof of mailing provision? Or it goes into that issue. The proof of mailing standard ensures and gives comfort to insurers or anyone else sending a notice that they don't have to prove, once they've deposited with the Postal Service that's trustworthy, there's no more fight. You don't have to deal with a swearing contest. You don't have to deal with the evasion of service. I mean, one consequence of the rule that my friend Mr. Kirby is proposing is all carriers, because as Justice Dietz points out, they have to have this language. This is mandatory. They will have to really overhaul or sort of rethink their systems about how to prove actual notice. And anyone who's tried to serve something through actual receipt, through Rule 4 fashion in the litigation context, it's tricky. Or if you're someone who's just receiving certified or registered mail, we've probably all been in this situation, matching up that timing to sign that green card is itself tricky.
So since whenever we interpret a statute, what we're supposed to be trying to do is to discern the intent of the legislature, what, in your view, is the purpose of the 5-day notice requirement? What's the legislative purpose for that?
Sure, just selling. This, I think, is one of the more potent arguments the other side. If I was in Mr. Kirby's shoes, I'd be emphasizing this point as well. And you'd think there'd be more law that talks about this, because the consequence of saying that reference to 5 days automatically defeats the proof of mailing provision is that would really destabilize that area of the law. The best case I've found on this is a case from Michigan called Noel, and I can find the site for this. It's not the exact same provision. The site is 648 Northwest 2nd, 157, Noel v. Titan Insurance Company. And what the court there says is, the way we're going to read this is an insurer has to put something in the mail reasonably ahead of time so that it will be, they envision it will be received in time for the clock to run. And I don't understand the plaintiffs to have challenged that, notwithstanding the arguments at a higher level than Mr. Kirby was made. This was put in the mail on May 22nd with a cancellation date of June 6th. There's ample time in between to satisfy.
But really, my question, though, is about legislative intent. And so why have a notice period at all? What's the legislature, in your view, trying to accomplish with that?
Sure. No, I agree for sure that one of the purposes here is to ensure that an insured is not surprised by a cancellation, can take any action, based on the cancellation, and can keep their property insured. I'm not fighting with any of that.
Going to, to the word giving, don't you think most people, if I say I gave my wife a diamond ring, she probably wouldn't agree that I gave it to her unless she received it. Don't you think that's how most people would understand the verb to give, that receipt is part of that?
I'm 100% certain that in that context, my wife would feel exactly the same way as your wife on that, for sure. But I think the context is different if you said, I gave, like, for example, I just had my birthday. My son and my wife gave me a Carolina Hurricanes jersey. And how did they do it? They went online to NHL.com, they put it in the mail, and the mail arrived. And that was the form of giving. So I would go back to Justice Dietz's questions, which is, it's all about the context. And I agree, by the way, that this court's decisions say we turn to non-legal dictionaries at times, and that makes sense. And at least based on my review of dictionaries, and the court
But in Justice Dietz's example about the email that goes to junk mail, you do receive it, right? It's in your folder, or it's in one of your folders. You just don't know where it is. It's like having something in your house and you can't find it. Isn't that right? I mean, you've received it. You just don't know where it is.
Yeah, I don't have a square, I'm not trying to evade the question. I don't have a sort of a square answer to that. I would say, I think if I had something that went to my spam filter, I would think, we have spam filters for good reason. Your email should probably be able to get around it, but I can see the other way as well if you're sending it. So I'm not quite sure where it lands on that, and that's one reason why I've struggled a little bit with, I think, the reasonable argument from my friend that, well, they could have just emailed it. Wouldn't that have been easier?
And so really, it sort of comes to this. If we say mailing is enough, do we defeat the legislative intent, which is, if that intent is to give the homeowner an opportunity, a reasonable opportunity to obtain supplementary or other coverage?
Absolutely not. The answer is no, and let me say why. First is, just again, starting with the text, giving notice, the most natural reading of that is that you're going to take a written document and put it in the mail. So that is consistent with the text. 2, throughout Chapter 58, the General Assembly refers to mailing as the means of giving notice. So Chapter 58 is probably described accurately as a patchwork of, different notice terms, but one thing that's clear is the General Assembly believes in mailing. There are even multiple times where the General Assembly refers to giving by mail. So I don't think interpreting giving as allowing mail is at all at odds with that. If anything, it's quite harmonious. Second is that, again, there is a distinction between does giving notice allow you to put something in the mail, and does this language completely forbid or prohibit this proof of mailing provision, which again is uniformly adopted and has all kinds of positive reasons behind it.
And isn't it possible the 5 days is in there because, so the legislature understands that most insurance companies do not also run like parcel delivery services. And because it's written notice, someone's gonna have to physically deliver it to the policyholder's home. So the thought may be, we don't want a scenario where they're getting it, the notice, and the time has already expired. How long do we think it typically takes for intermediaries like the Postal Service or UPS or FedEx to deliver a letter? And they say a couple days, so 5 days is gonna ensure that you're getting it before your policy's canceled and give you time to find another policy. So it's just you have to draw the line somewhere. It could have been 10 days, could have been 15 days, but it doesn't seem to me that precludes the understanding that, as you're arguing, giving would necessarily mean the receipt. But what I understood to be the strongest argument your friend was making in this context is your position also is not the unambiguous correct answer, that the statute is just truly ambiguous here. And then I understood your friend's argument to be, well then before we put it into the language of the policy, which we're sort of implying it's in there, we first resolve the ambiguity. And the law says to do that, we construe it in favor of the policyholder. So we construe it to mean receipts required. Then if we stick it into this insurance contract, the standard policy form language is conflicting with it and would have to be overridden by the statute. That to me seems to be the strongest argument. So what's your response to that?
I totally agree that that's where I'd be headed. So let me address this straight on. One is, I do not think it is correct to say that a statute concerning insurance policies are construed always in favor of the insured. That's not my reading of the cases. And in fact, if you look at the dissent in the Court of Appeals, it cites a case called either States Capital or Capital State, something to that effect. And what that says is in the context of a compulsory insurance statute, you construe it in favor of the insured. Obviously, there's fire insurance is not compulsory, and the plaintiffs here went years and years without having any fire insurance coverage. So that is not aligned with my understanding of the law. And my understanding of the law is consistent with what Justice Dietz asked, which was it's the policy terms. Another point that my friend put in his brief, and maybe he was alluding to, is the concept that if you have a remedial statute, it's liberally construed. That also does not really help much at all. One, because if you look at a world where you have a binary choice and a statute is either penal on the one hand or remedial on the other, I mean, most statutes will be remedial, and it can't mean that sort of liberal construction means, well, plaintiff wins all the time. Then you'd be truly dispatching with all the other tools of statutory construction. What I think that the best reading of that, or understanding of liberal construction, is just giving it a fair reading. If you look at the Garner Treatise that we cite in our brief on page 365, he's a very interesting discussion of how that's what liberal construction really means. So I don't think that argument gets very far. And I think when you look at all the different tools, what do we think the General Assembly might amend? Giving notice is pretty broad. Like, that language is pretty broad. What do we reasonably think that means? That any means of notice that could be effective can be used. There's just nothing limiting the methods. And that's why I don't think there's anything remarkable that the policy unambiguously states we're going to mail it. And
So correct me if I'm wrong, but the HO3 form requires you to, if you're going to mail notice, to mail it 10 days prior to cancellation. Is that right?
Yeah, it's a little surprising how the language is. Hopefully Nationwide will not take it out on me for using those terms, but it says we will let you know 10 days beforehand. And so you might say, well, what does that mean? Let you know. And I do think that means that you have to send it I don't think that it would be read the clock starts running if you put it in the mail at day 10. It has to reasonably be gauged to meet that period.
Well, what I'm wondering is, can you say, well, if the statute isn't totally clear, but the legislative intent was to give 5 days to obtain, the homeowner 5 days to obtain a new policy, that this is a reasonable interpretation of the statute, that is, mail it 10 days ahead, and that's a reasonable effort to ensure that the homeowner has at least 5 days to do that.
I would say, and please correct me if I might be misinterpreting your question. I fear that I am. The 10 days is more generous than the 5.
That's my point.
Yeah, for sure.
So my point is, could you say, well, the statute is not clear. We do think the legislature wanted the homeowner to have the 5 days. Agreeing to mail notice 10 days in advance is a reasonable effort to ensure that the homeowner has that 5-day period that the legislature seemed to have intended.
Justice Allen, I'd agree with that, and I think that's also faithful to the language in Article 44, 16 about conforming in substance. That conforms in substance with what the statute requires. I do also want to mention on the question from Justice Riggs about the prior AAA policy, which transcript page 74, that's what the testimony says, which is, if we're using the traditional tools of statutory construction and we're looking at legislative intent, what are the purposes behind the rule that my friend is advancing here? One thing that's interesting as I get into these purposes is if you look at these out-of-state cases, which I've studied pretty closely, I'm sure many of you have studied pretty closely, when you drill down to first principles of what these cases from the 70s and 80s from these smattering of states decided, it's really conclusory. They don't really say much of anything, but one thing that's mentioned is we don't want homeowners to be surprised. Well, here, there could not have been any surprise whatsoever on this record for the reason that Justice Riggs said, which is the very reasons why Nationwide issued a cancellation are the same reasons that AAA issued its cancellation.
But isn't there an argument then that why are we reaching this question of statutory interpretation if on this record the appellant had notice, or at least constructive notice?
Yeah, no, I think that's apparent, right? I mean, we've had questions, and there's no question that there was sort of notice beforehand and notice afterwards, and so this does not present, it presents a fundamentally bad record for I think the policy arguments that my friend is introducing. I have not found precedent about this concept of whether notice separate and apart from that express letter would constitute that. I think it's a common sense fair way to resolve this, no doubt, but I don't want to oversell any sort of precedent or jurisprudence on that.
Well, and so you brought in your brief a lot of the practical questions about requiring certified mail or actual receipt would cost money, it would disrupt the industry, turn it on its head. I mean, isn't the flip to that, if we say we put it in the mail, maybe it's only 2% of all pieces of mail that go through the U.S. Postal Service, but if I'm a diligent homeowner, doesn't that mean, especially if I know that 2%, then the obligation then is on me to call every 5 days to make sure that there hasn't been a cancellation that I just haven't received notice of, and then what does that do to insurance companies, their customer service, that they're getting these calls? And I know not everyone's going to do it, but isn't that, if we're getting into the practicalities and disruptions to the industry, doesn't the rule you ask us to adopt invite a different kind of practical problem?
I'm hoping not, in part because, one consequence or byproduct of my friend citing back to a case from 1934 as sort of his lead case is we're not seeing this situation come up. Like, there is not a whole bunch of cases about this happening, and the reason why is that fundamentally the system must be working. I mean, maybe I'm missing something on the ground, or I haven't found the right secondary sources describing what's happening, but because the mail works, And because of premium refund checks and because of all these other notice factors, it works. So I don't think that the rule that we are prescribing is the status quo, which I think is, unambiguously clear language that has a lot of policy, a lot of strong justifications behind it. And I mean that not just from the reasons why a proof of mailing standard is sensible because of the efficiency and reliability of it. But one part that, again, could be wrong about this, we're sort of looking into the future, but one important feature of the current scheme or framework is that North Carolinians, like the plaintiffs here, can get homeowners insurance quickly. They can get a binder quickly. So if you're getting a mortgage for your new home purchase, you are not going through some massive underwriting process. And the trade-off for that is if an insurer is going to issue that for homeowners and provide ready access to insurance so that people can own homes, there has to be a clear, reasonable means to cancel them based on that underwriting process.
But doesn't that argument also work? I mean, there are some states where, whether through statutory interpretation or otherwise, the courts have said that giving notice requires actual notice, and it isn't the system is working in those jurisdictions as well. Suggests that argument kind of cuts both ways.
Well, that's a great question. So I went back and looked at the states cited in the plaintiff's brief and found out, well, what's going on there? How can this be the case? All of these states, these cases were decided in the 70s and 80s. A lot of things have changed. Here's what I found. So, and again, remember, most of the plaintiff's cases are out of state, don't involve a statute. They were just policy cases. So Vermont, there is no fire policy statute. In South Carolina and Rhode Island, there are both statutes that expressly contemplate mailing. In Pennsylvania, this is very interesting, there's actually a case called Certain Underwriters at Lloyd's of London v. Clark. The site is 1998 Westlaw 404807. I should have caught this earlier and had it in my brief, so I apologize. But in this research I did anticipating this question, the Eastern District of Pennsylvania addressed this question. They have the giving notice statute, they had a proof of mailing provision, and they found for nationwide, or not for nationwide, for the insurer in that case, for all of the reasons that we have been discussing here. Kentucky, the Osborne case, has a statute that specifically allows for proof of mailing. Florida, which is the jurisdiction that issued the Nunley case that the dissent in the Court of Appeals relied on, they have no fire policy statute. Now they have a different statute that says notice shall be given 20 days before canceling a policy, but the courts that have looked at that have said that that is consistent with proof of mailing. The case to look at there is called Ruiz, 677 Southern 2nd, 1336. So again, if you do further research, you'll find out in these states, the HO3 policy, just as it is across the country, is the predominant policy form.
Just to close the loop on something that was here, so, and, earlier on, you sort of mentioned this idea that, when you or your client is drafting these policies, but to be clear, Nationwide did not get to choose this language, as you were just explaining. That's the government that tells you you must use this language. So all your client did is use the exact language that the government said to use, and is now being told the government apparently, in the sort of the worst case scenario, or accepting your friend's argument, has created an internally conflicting series of provisions. But it would be odd to blame your client for that, since all you did was follow the law. It seems like someone should go to the Commissioner of Insurance and raise a claim there, which certainly are claims that could be brought for approving that policy form. Do you agree with that?
I 100% agree that Nationwide had no discretion. And if they had used a policy form other than one that the commissioner approved, there would have been legal consequences to that, no doubt about that. And that is, I think, the right segue to Mr. Brock, who will speak for the Rate Bureau, because it's the Rate Bureau that promulgates these policy forms that the commissioner expressly approved, as the record shows. So I will cede the remainder of my time to Mr. Brock, though I welcome further questions from the court. Thank you very much.
Thank you, counsel.
May it please the court, my name's Walter Brock from Young, Moore and Henderson, and speaking on behalf of the Rate Bureau. I do thank the court for giving us the opportunity to speak, to address questions that you may have about the practical implications of this, and to address questions about the compliance with all the statutory and regulatory requirements for providing for homeowners insurance policies. And the Rate Bureau's interest here is to defend the policy itself and defend a party who has relied on compliance with the policy. The record shows that the Rate Bureau is charged by statute with promulgating the policy forms that are used, and that it is required to submit those policy forms to the Commissioner of Insurance, and the Commissioner of Insurance then reviews those policy forms and approves them. The record also shows that there was specific reference to compliance with the standard fire policy, and so that was undertaken. And the Rate Bureau's process... What would happen if the Commissioner of Insurance said no? What happens when one does not get approved? And you will see in this record there were questions that were raised about it, and a non-approval, the questions were answered, then there was an approval. So if the commissioner doesn't approve the policy form, then you have to resubmit the policy form in a manner that the commissioner believes complies with the law.
So in a sense, your organization is a nonprofit. You're not part of the government.
That's right.
You're drafting the forms, but ultimately, they don't become a part of the law until the government approves them. The Commissioner of Insurance has to say this will be the form, and then that becomes the form that the insurance industry is required to use.
And the Rate Bureau is a unique animal, but it is created by statute, and insurers who are issuing what are referred to as essential lines, and homeowners is one of those essential lines, have to work through the Rate Bureau. And that's because these are essential lines. They're mostly personal lines, and therefore we want there to be standard policy language, standards that folks can rely on, and that's what's going on here. Same with automobile. That's an essential line. And so.
But you do agree that even though you're created by statute, it's still this court's obligation to interpret what the statute means.
Absolutely, absolutely. And the compliance with the statute starts with complying with the regulatory process. And Justice Berger raised in the previous case the rulemaking process. Well, in effect, this is an administrative process. If there are parameters here to be clarified, it was done by the insurance department approving this form. And what we're talking about is we're talking about a system that works. The proof is in the pudding. It's a fair form of notification. It's effective. How do I know? How many cases have been before the Court of Appeals or this court about someone not receiving notice of cancellation? The proof is in the pudding. It's important. The Rate Bureau, the Department of Insurance, all want this to be a fair process. And the practicalities of it are that it works. It's reliable. It's a method that's reliable in providing actual notice. But what the policy language says establishes certainty that it is that proof of the mailing, and you got to prove that you made the mailing, proof of that mailing is proof that the notice was given. And so we believe that Nationwide had no choice but to use this policy form. This policy form is not incompatible or inconsistent with the plain language of the statute. In the parameters of explaining or clarifying what needs to be done to effect notice, the Commissioner of Insurance has approved language which says that proof of mailing is proof of notice. That's not changing that the intent is to provide actual notice. But as a practical matter, what you have to do is how in an industry, and regrettably, there are tens of thousands of cancellations annually by the insurance industry in North Carolina. That's the nature of the beast. There are tens of thousands of them. So we're not talking about a few isolated situations where there's a cancellation. So we're talking about an administrative issue that has really proved to work. And any attempt to undermine what has actually been working for the citizens of North Carolina runs the risk of making insurance more difficult to obtain, delays in binding insurance coverage, higher underwriting standards, and other issues that would disadvantage the consumer in North Carolina, where the system is working. The system is working. I see that I'm about out of my time. I appreciate the opportunity to speak to the court today.
Thank you, counsel. Rebuttal?
Thanks, Your Honor. I think I'm down to about 90 seconds, so just to address a couple of points here. This whole argument about how the Commissioner of Insurance has approved the policy language and therefore they are required to write this, there are several flaws with that argument, but one of those, the least of which, is if adopting that rationale would effectively prohibit the courts from ever reviewing policies to see if they comply with the statute, because the rationale they've given, which is the policy was submitted to the commissioner, he or she approved it, therefore it has the imprimatur of law. That would basically insulate the insurance industry for any provision in their policy, even if it did violate the statute. And there have been many cases in North Carolina where our courts have held that policies and provision do in fact are inconsistent with the provisions in the statute. So that in fact does happen and has happened. The other point I would like to make clear, I didn't get into this too deeply before, but the position that we are articulating today is nothing new. It is well-established law. And the case, I'll just quote very briefly, when this court addressed the same policy language 90 years ago in the Wilson case, this court wrote, "The cancellation by the defendant did not and could not, under the provisions of the policy, take effect until the expiration of 5 days from receipt of the written notice by the plaintiff." They clearly said receipt. In that case, they quoted the policy, but the policy and the statute had the same language. So authority from this court indicated that it has to be actual receipt, as well as the cases from other jurisdictions. Thank you.
Thank you, counsel. Thank you, everyone. Mr. Clark.